following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the laws related to the establishment of public-private partnership in development of state services. Sri Lanka's most recent budget expressed its willingness to go into private investments in order to maximize the productivity of certain state-owned companies. What is the legal framework that governs this? Is there a question of ownership when it comes to understanding the decision-making process within these institutions? What reforms need to be introduced to make sure private-public partnerships occur for the benefit of our country? Welcome to Law, Land and Liberty, where we are keeping with the promise of bringing in a contemporary legal topic and breaking it down for our viewers. Now we are just fresh off the budget, and a lot of discussion is happening pertaining to a lot of inclusions within the budget. And here at Law, Land and Liberty, we are trying to get a breakdown of the legal aspects of all of this. And today we are going to discuss this issue of public-private partnerships, basically under the topic of business agreements, so as to give our viewers an understanding of what investments are like, what actual foreign direct investment is going to look like when it comes to the legal framework within our country. And to give a breakdown, we have with us a veteran, an individual who has been practicing within this field for quite some time, President's Counsel, Nihal Jayawardene. Thank you so much, sir, for coming and joining us on this topic. President's Counsel Nihal Jayawardene is an in-house counsel of Capital City Law, Colombo. He's a solicitor of the Supreme Court of England, and he's the chairman of the Company Law Advisory Commission, amongst a lot of his other accolades, which I won't be getting into details, but we will try and draw from his experience within this field. What we usually do within this program is we give our viewers a breakdown, and I'm going to give that specific breakdown so that our viewers can follow actually where we are going to take this discussion. So firstly, we are going to talk a bit about the Companies Law Act, as in the number 7 of 2007, so as to give the viewership a basic understanding of where we are going to draw from the, one would say, the principal act that we will be discussing within this discussion. Secondly, we are going to talk a bit about the laws related to the conversion of state-owned enterprises to either PPPs or public-private partnerships. And finally, a bit about the key reformations that are required in this specific field.
Hello, my name is Selmini, and I am a second-year civil engineering student. So, my question is on key provisions. What are the key provisions within the Companies Act within Sri Lanka that governs issues related to private and public partnerships?
All right, let's get directly into the discussion. Once again, thank you so much, President's Counsel Nihal Jayawardene, for joining us. Sir, I believe within our discussion, though we have a limited amount of time within a very vast field, we'll try and draw from everything you have experienced within this field for quite some time, and I want to give a substantial amount of time to talk about reforms, because that is something that you have been involved in. Now, the Companies Act number 7 of 2007, which we discussed on this program actually a few weeks back to give the basic outline of what company law within this country is. Now, the most important question within our program is public-private partnerships. What are they? How are they identified? What are the entities involved? Because people have the question within their minds, okay, is this selling? And who has ownership? So these questions that the layman and even law students would be having range in a wide variety when it comes to investments. The first segment, I wanted to start with Companies Act number 7 of 2007, because it, again, as we said within our introduction, gives sort of like the principal identity to this discussion. Where do you begin in this discussion if I pose the question of, okay, business agreements when it comes to large-scale infrastructure projects or large-scale institutions that provide some important service to this country, without going into the details of what those services are? Where exactly does the law begin? How should we begin to understand this?
Now, the company law, actually the Companies Act facilitates the implementation of very many things in the form of legal entities called companies.
Right.
So the law basically, which evolved over a period of time, was based on the English principles relating to company law. And in the early 90s, we realized that our law was lagging far behind. It was almost the identical English Act of 1948. So this reforms process started, and the reforms process started with the view to make the law simple and sort of user friendly, so that the commercial community understands it, maybe even without the assistance of a legal mind, because it was very technical at one time and could not be understood in a way properly. A company per se is a legal entity which has a separate existence from its owners or the parties who form it. I think these might have been aspects which you would have dealt with in the previous programs. So this kind of an entity can enter into contracts and can sort of do so many things that a natural person can do. So much so, this act, in the process of simplification of the law, has provided a company the ability to do anything legal. Section 2 of the Companies Act is, I think, if not the most important section, is one of the most important sections. Earlier, if a company wants to do something, that had to be stated in the object clauses which were found in the Memorandum of Association. In the process of simplification, the two constituent documents have been done away with, and it has been brought down to one constituent document. And certain companies which are by any other law required to have object clauses could have those object clauses in the articles, which is the only constituent document now. That has taken away the concept of ultra vires, where the company had the power only to do what is stated in the objects. So it is a legal entity which can enter into any form of a contract and also can do anything which is legal. That's the starting point. So this kind of a legal creature can be used for the achieving of various forms of activity. Now, there was a time where many things were done by state institutions. And when you say state institutions, there were times at which those were done by government departments.
State owned, that would be the definition, or?
You cannot call it a state owned institution because it did not have the corporate status or legal entity status was not there. So that is one reason why they deviated from government department and they started creating corporations. Now corporations also, government corporations also had a structure like a company where it had the legal existence as a separate entity. It had a board of, either board of management or board of directors, whatever they call it. It is like the board of directors of a company who direct the management of the company, supervise it, and then evaluate and also give directions as to how this has to be done. So they were the people who are responsible for any action that the corporation takes, like in a company. And
so just to get a clarification there, so then that will be governed under the Companies Act?
No,
that won't.
No. Those are corporations. There were several types of corporations. Just to without going into a complicated kind of a situation, there are government corporations or statutory authorities established by a particular law relating to that entity alone,
Right.
like the electricity board and say whatever certain corporations that we have, and there are certain corporations which are created under the Industrial Corporations Act or the Agricultural Corporations Act, which will be created by a publication of a gazette notification. Those also will have that legal entity status and also the perpetual succession and all those characteristics that a company has.
Yeah.
So those were created for the purpose of giving that entity some kind of a freedom.
Right.
So that within that freedom, the board of directors or board of management, if they apply themselves with their expertise in the field, in a given field, they would have done the things that a company can do today.
Right.
So what was expected at that time, at the time of creation of the corporations, was to give some kind of a managerial freedom to that institution.
Just to get a clarification there, so the managerial freedom will be given. How does the appointment of said management happens? As in, is there a framework there?
Well, I mean, that is also some a misunderstood concept. Now, way back in 1957, when these corporations were just coming up,
Yeah.
In a speech made in the parliament by Dr. N.M. Pereira, he mentioned about certain things relating to the Counsel Cement Company, which was operated as a corporation or a part of a corporation.
Right.
And he was saying that the operational freedom that was expected to be given to a corporation is to free that from various government controls. Now, there were a lot of red tape in the government sector.
Yeah. Yeah.
Financial regulations, administrative regulations, and various things. So, to do anything, you have to follow that.
Yes.
And even to recruit some person, again those regulations had always been a deterrent.
Basically functioning like a government institution then.
Yes. No, I am not referring to corporations, but before the corporations were
Existed.
Came into being,
Right.
as I mean, I think there are about 200 so
Yeah,
corporations
Yeah.
which are in the country now. Now, prior to those came into being, the government departments did now, Public Works Department did the roads and various other
Exactly.
public works.
Yeah.
And now there is this Road Development Authority for that. And likewise, there are so many things. There was the Civil Aviation Department.
Right.
Civil Aviation Department became an authority in 2001,
Okay.
because there was a international obligation on the part of the country as a contracting party to the Civil Aviation Convention to be fulfilled, and with the red tape that existed in the government sector, that could not be done, and therefore the ICAO, the International Civil Aviation Organization, Sri Lanka being a member of that, was directed to change from the government department status to an authority, enabling the authority to even recruit people who are competent in that field, because it's a sophisticated field.
Yeah. Yeah.
Safety of aviation had to be secured, and you had to recruit people to monitor the competence of people like pilots and that kind of people. So, I mean, I just wanted to take this as an example. The problem that was there was the financial restrictions that existed in the financial regulations that were applicable to the government department. and they always had to look outside and take various decisions which are not which are not conducive to the purpose for which such an organization should exist, because they had to primarily ensure aviation safety of this country. So they created that. So when they created such organizations, they had to bring in people with expertise in that field, as well as in keeping with the other government policies to carry out the functions in the most effective and optimum manner, which could be done even under the cooperation structure. But why it did not work was that later on most of these corporations became yet another government department kind of a thing. They started following the same ARs and FRs, which they were not bound to do, because the board has to be the body that has to be responsible for the direction of a corporation, and the board had to take the activities forward in the way that they thought is the best. And for that matter, they had all the powers, and they could have exercised those authorities. Now, when you compare that with a company, usually a company is incorporated for commercial purposes, and they look at the profitability of the organization, the effective ways of providing the service, and the customer relations. All those things are being looked at, and they would sort of give a product which would satisfy all those conditions. So even what I would say is, there are legal authorities who have gone into that, and they have concluded that the premium body of a corporation is its board of directors. They have to not only take decisions for the optimum performance of that organization, but they should also take the responsibility for their decisions. That is where
the accountability.
Accountability. Many were reluctant because of the fact that they may have to go before the COP and answer questions. Of course, answering the questions, they should be prepared if they take the correct decision. So now, what I was trying to elaborate was that there were government departments which had these restrictions, and in the process of evolving, they evolved into corporations. Corporations could have done what they were expected to do, but because of these personal, political, social preferences, and I would say even prejudices, they did not want to sometimes exercise their powers. And now this necessitated to look at these things in a different way, whether we could incorporate companies of which the ownership or the share ownership is with the government, and let those operate as normal companies, and directors who are supposed to take decisions to take those decisions the way those should have been taken.
So I think it really opens the window to our next segment, where we talk about the incorporation aspect. We'll take a very short break. You are watching Law, Land and Liberty. Stay with us as we continue this discussion with President's Counsel Nihal Jayawardene.
My name is Thinuka and I'm a medical science student. What laws are present within our country for the conversion of state-owned enterprises to joint ventures?
Alright, welcome back to Law, Land and Liberty. We are in discussion with President's Counsel Nihal Jayawardene. We just passed the first segment on a lot of identifications pertaining to the entities that are involved. Mr. Jayawardene, I want to get a clarification now. One thing that stood out for me was you identified these things called authorities that were established. I think the Civil Aviation Authority was one of them. If we can, as we move into the conversion of state-owned enterprises, which is our next segment, and there is a specific act, I think it's government-owned business undertakings into public companies, conversion of public corporations or government-owned businesses into public companies, the Act 23 of 1987, a pivotal sort of act which a lot of people would not be aware of. I would want to get your elaboration on that, but at the same time, things like authorities, either institutions, in these terms are people here, but is there some demarcating line about how these differ from one another, even either departments? I think the UDA comes to mind, things like the Road Development Authority comes to mind. What is their mandate when it becomes an authority over another private or public enterprise?
Well, the legal status of, I mean, whatever you call it would be almost the same.
Okay.
Yeah, it's a legal entity which can do the things for which it has been established. So, like in the previous company law regime where there were object clauses,
yeah,
there are objects for which these organizations have been established. Now, for instance, you mentioned UDA,
yeah,
Urban Development Authority. Now, when you usually refer to a government organization referred to as an authority, it usually has regulatory powers as well.
right.
Now, UDA is a government authority which facilitates the development in urban areas.
Okay. Like the PUCSL, which will completely follow a mandate of regulation. Here,
Yes.
authority would have the regulatory power also.
Regulatory power in respect of certain things. Then there is, I mean, even some corporations do have.
Right.
Now, then boards.
Right.
The other term that is used.
Okay.
Now, boards are also sometimes have this dual function, and now and there are certain corporations also which exercise a regulatory function to certain extent. Now, one classic example is the Rupavahini Corporation, which
right.
has certain regulatory powers, whilst it being a service provider in that sector, media sector.
Yeah. Yeah.
It is an organization which does that, and it is regulating similar organizations.
True.
Broadcasting Corporation is another.
Yeah.
So, these are, of course, I mean, if you the ideal situation would have been there should have been something like a broadcasting authority or some media related authority which would have regulatory powers over all service providers.
Yeah.
That would have been, I think, it would have been able to exercise an independent
Yeah.
kind of a regulatory role.
I think we discussed that aspect also. I think which I want to like give you some time on, sir, when we talk about reforms,
Yeah.
about what we need to take as next steps. Now, just to, I hope I'm not deviating too
No,
much,
no.
but I want to discuss with you, sir, about this the private-public, the partnership aspect. Now, there is either foreign investments coming in or joint ventures with the state. What exactly does an agreement like that look like? Because now the budget opened the window and mentioned, okay, there's going to be restructuring that's going to happen for certain companies. Some may be profit making or not. And you mentioned, I think you outlined one of the key issues that these the state-owned companies have had in terms of their leadership. in terms of how the leadership is sort of the accountability aspect and everything. Where does the entire either the legal framework for these public-private partnerships come into play? How do we understand it?
Well, it can be in so many ways. One is you can create a company, a special purpose vehicle for that purpose,
Right.
where certain shares would be owned by the state, and the Act requires that the shares owned by the state would be held by the Secretary to the Treasury. That's a legal requirement. And in accordance with whatever investment agreement, either a foreign investor or a local investor can take part, depending on the subject area of that organization. That is a simple way of creating a public-private partnership.
Yeah.
Then there are certain government corporations and certain business undertakings. These business undertakings is a term referred to some of the private businesses that were acquired by the government under the business acquisition, I can't remember the exact name.
Yeah.
In the Act created, I think, in 71.
Okay.
That Act.
What does it essentially do as
it permitted the government to acquire certain businesses which had eternal labor related problems, or I mean, if there was a deadlock kind of a situation,
the state took it in?
Yeah, state took over and appointed a competent authority. I mean, many competent authorities were not competent enough to handle that situation.
Specific job, yeah.
Yeah, and those were also identified under that Act that you mentioned, the 1987, 23 of 1987, which was popularly known as the Conversion Act.
Right.
Plus, any government corporation which is in existence at the moment, or a part of that corporation. That is, the entire corporation can be converted into a company as the first step.
Right.
Now, the government selected certain corporations which were not performing to its maximum,
Yeah.
or certain corporations which need not be operated by the government.
Okay.
Due to the nature of their activity, or where you could engage foreign investment and can develop it into a kind of a multinational business, or a very profitable kind of a business, through which the government could own, rather earn by way of dividends,
Yeah.
revenue to the government,
Yeah.
as revenue, as well as when the income of the income that entity generates,
Yeah.
could also bring additional income to the government revenue as well. So these are the reasons why this Act has been looked at. The corporations that were not performing to the optimum level were converted, and this took place particularly in the early 90s.
Right.
And there were many corporations which were converted into companies. Like I'll take one example, the Sri Lanka Telecom, which was under the Post and Telecommunication Department. During that period, even to get a telephone connection, it took about 8 to 10 years. You had to wait in a waiting list, and a telephone call from here to a place like London in 1989 took about 300 rupees a minute. So that was the type of organization that was there, not only due to the mismanagement or whatever reason, but also due to the lack of technology being applied.
Right.
So initially it was converted into a corporation,
Yeah.
Sri Lanka Telecom Corporation, which was converted using this Act, 87 Act, 23 of 87. With the conversion, by the invocation of section 2 of that Act, all the shares would be vested with the Secretary to the Treasury, and thereafter they would be looking for strategic investors.
Okay.
That's the term used. A strategic investor is a person who, in addition to the funds that he has to invest in this, he has a expert technical knowledge relating to this area. So when they were looking at investors for the Sri Lanka Telecom, which became a public company by the Conversion Act, they were initially wanting to sell 35% of the shares of that company to a strategic investor, and they call for expressions of interest, and they were looking at a few very efficient kind of investors, and out of them they selected NTT of Japan,
Right.
Nippon Telegraph and Telecommunication Corporation, as the strategic investor, and he was vested with the 35% shares, and they were, in addition to the 35% shares, they were given the management of that company under a management agreement. So they were, NTT was the manager of Sri Lanka Telecom under a management agreement. The larger number of directors were appointed by the government, because the government held 65% of the shares initially, and I think 5% of the shares were given to the employees.
Yeah.
So in that ratio, I think there were directors appointed, and although there was a lesser number of directors by the managing private partner,
The strategic investor.
the strategic investor, the managing director's post was also given to the NTT.
Right.
And he could at the beginning spend certain amounts of money at his discretion. There was a ceiling placed, and I mean, in this agreement they use various mechanisms. One is that there are certain reserved matters for which you have to obtain the government director's consent or the assent in taking making a decision. Then there was the other concept that was used, where you had a share called the golden share.
Right.
It was also an English concept. For the reserved matters, you had to obtain the golden shareholders' assent.
Okay.
And that golden share was always held by the Secretary to the Treasury, who held the government shares.
Okay.
So those were certain mechanisms that were used in order to have some kind of a check on the party which has a control in management.
Right. So I need to interrupt you there. We'll take a very short break and we'll come back, and I think we can continue the discussion to reforms, because I need to give you some time on that. You're watching Law, and Liberty. Stay with us as we continue this discussion with President's Counsel Nihal Jayawardene.
Charanya, and I am an economics student. What are the key legal reforms required in the field of private-public partnerships for the maximum benefit to be received by the Sri Lankan economy?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Nihal Jayawardene. So I think two very informative segments that we just passed, a lot of clarifications even personally about how this actually works when it comes to strategic investors, as you mentioned, and how they work with the state basically. I need to let you continue on the line of thought that you were going in, which was very interesting as well. But at the same time, sir, where do you think reforms need to come into place in order to make this more efficient? Now there is still, without getting too political, there is a public element to this where they are not clear about what selling of shares would mean, whether that is complete ownership to someone else, what exactly is the functional element there. At the same time, so what do you think are the key reforms that need to take place in the near future? Because we're looking at a difficult period for the country, and in this time period we need the kind of foreign direct investment that we are looking at, that we're talking about. Where do you think the key reforms need to take place? I think this falls very well into the fact that you advise competent law matters as well, and you are within that commission. What is the discussion that's taking place right now?
Well, I am not completely aware of the nature of whatever the discussions are going on, but there is a legal framework even now within this act to take those actions that I was describing a little while ago. So what they have to do is they have to get a proper strategic investor, locally or foreign. I mean, you need not emphasize on the foreign investment alone, but foreign investment becomes much more important presently because it brings in the currency problem also will be sorted out to some extent. So that is why I think even during the recent past they were much more concentrating on investment rather than borrowing and various other forms of financing the needs of the country. So anyway, I mean, that's a political thing where the decisions will have to be made by the political authorities. But during the time that this act was made use of in a very effective way, there was an institution called Public Enterprises Reform Commission. PERC.
Yeah.
And that was an organization again which I should say, I mean, it existed for a short period and thereafter it was abolished. But during that short period, I would say that was a government institution. It is typically a corporation. You can call it a corporation or a government authority or whatever you call it. That is the type of state institution that has been established for the purpose of carrying out, supervising, advising and taking decisions pertaining to the league, or rather the reforms that were carried out for government owned institutions.
That's the kind of body you were talking about before, so about overlooking all of these corporations, is it? Or
no, it had I can't exactly say whether it had any regulatory kind of a power, but it was a facilitator,
right,
mostly,
right.
And it had people who were in charge of that, who understood the purpose.
Like the Export Development Board, would that be a comparison that we can take?
Well, Export Development Board, I don't have any personal experience, but
right.
Export Development Board is also a facilitator, more or less. But PERC, I can very clearly say, because I also have been from the Attorney General's Department, I was in the team of consultants who advised the PERC on these privatization related matters. During that period, there were during the period that PERC existed, as I mentioned, they had understood their mandate.
Yeah.
And they took very good decisions, and they carried out with accountability, and also taking up the responsibility of the actions that they took.
Yeah.
And during that period, this word privatization, I don't like to use that word because that gives a different kind of a meaning.
A negative connotation attached
yes.
to it.
Now, getting parties to invest in a converted company, I would say, put it that way. Sri Lankan Airlines,
Right.
it was known as Air Lanka at that time. Air Lanka, again, 49% of that entity was given over to a strategic investor,
Right.
a very strong operator in the aviation field, and that proved to be a very successful operation.
Okay.
Of course, I mean, a party will not invest in a venture here if they don't get an advantage out of it.
Exactly. I wanted to establish that understand that as well, because when it comes to a lot of private entities, I mean different kind of private companies, the one motivating factor for the top tier, the executives, would be the kind of dividends that they'll be gaining in the event the specific company does well, either in terms of dividends, multiple avenues. Is that sort of motivation required here, or is it that the dividends and whatever revenue that is made is completely directed to the state? Is that how it functions? Do you think that is some place that we need to change?
Well, I mean, we can't deviate from practical concerns.
Right.
Now, if we take that investment, the investment that we were just discussing earlier, Emirates invested in Sri Lanka because that relationship could have been made use of in so many different ways to the advantage of both parties.
Right.
That is the ideal kind of a public-private partnership.
Right. Like the flight routes and everything.
Flight routes can be shared.
Yeah.
The routes on which one party is operating at a very high profit can be made use by the other party for certain other routes that they are operating on. So, they had to look at what are mutually beneficial, and they might have to even give up something for the benefit of the other partner. Likewise, the other party also may have to, give and take kind of a relationship has to be made aiming at a profitable venture together. And if that is approached genuinely without just thinking of what I should get, that is the kind of public-private partnership one should envisage to establish through this process.
Right. So I think there are a lot of things I want to discuss with you, but time has come against us. But I think the point you entered on is quite important, and it's a place that we can actually end this discussion as well about what an ideal partnership would look like and what their motivations should be. Thank you, sir, for joining us on this discussion. I think hopefully we can meet again on the program and discuss this topic or even another one pertaining to company law much more in detail. Once again, thank you, President's Counsel Nihal Jayawardene, who is the in-house counsel of Capital City Law, Colombo. He's a solicitor of the Supreme Court of England, and he's the chairman of the Company Law Advisory Commission. Thank you so much, sir, for joining us.
Thank you.
All right. The business atmosphere, specifically private enterprise, has a lot to offer to the functioning of state-owned enterprise within our country. In capturing this idea, former Minister of State in India, M.M. Pallum Raju, once said, "Public-private partnership in financing, service delivery and provision of workspaces and training of trainers must be promoted to meet the supply and demand gap in the field of skill development." That is all from us here at Law, Land and Liberty. If you had missed today's program, you can rewatch the entire episode on our YouTube channel, youtube.com/Ada Derana English. I'm Dhanidip Thanavasam. Have a great night.